Right, but neither Cohen nor Holder involved medical treatment, right?
No, so that's true, but that's just a label. And this court has also said that labels don't matter in cases like Bunnin. There's nothing conceptually different. Take Holder, for example. In Holder, there was a statute that said, don't materially support terrorists. You can materially support terrorists in lots of different ways. You could give them money, you could give them guns, or as in Holder, you could give them advice about how to commit their acts.
I understand, but when you look at the 10th Circuit's opinion, they talk about how there is a long historical tradition of regulation of medical treatment as a particular thing, the provision of these kinds of therapies.
Right, and the problem is the level of generality. There was also a long historical tradition in this country of regulating contempt of court and breach of peace. But what there is not a long history and tradition in this country of doing is regulating contempt of court and breach of peace when it's purely based on speech. And if you look at the history that the other side cites here, what is totally absent is the regulation of medical treatment that consists solely of speech.
So does the federal government agree with Justice Kagan's flip side scenario? So it doesn't matter to you that we're talking about Mrs. Chiles' form of therapy versus gender-affirming care form of therapy?
We do, and in fact, we think that's a strong reason in support of our position. Colorado's position, I think, inevitably leads to the conclusion that all the states in Scrimeti could have not only banned things like cross-sex hormones and prescription blockers, puberty blockers, but also therapy, talk therapy along the same lines. Even starker, in the 1970s, it was the standard of care, professional consensus, that being gay was a mental illness. So on their position, a state in the 1970s could have made it illegal for a therapist in the state to counsel a gay patient that they weren't mentally ill. That just cannot be right under the First Amendment.
Can you address Justice